Welcome to the latest episode of International Law Chats, a podcast from the American branch of the International Law Association, ABILA for short. The podcast airs on the first Monday of every month, and we hope you'll be able to join us each month. I'm Alison MacDonald, a barrister at Essex Court Chambers in London and a fellow at All Souls College in Oxford.
I'm Chiara Giorgetti, a professor of international law at Richmond Law School and senior fellow at the International Claims and Reparation Project at Columbia Law School.
And my name is Milena Sterio, and I'm a professor of international law at the Cleveland State University College of Law and also managing director at the Public International Law and Policy Group.
We're delighted to be sitting down today in person in Washington, D.C. with two exciting guests, Ambassador Namira Negm and Tafadzwa Pasipanodya. They both have extremely distinguished careers, which I'm not going to be able to do justice to in a brief summary, but here goes. Ambassador Negm, Namira if I may, is the first director of the African Migration Observatory, and she's also honorary president of the African Society for International Law. She was the first female legal counsel of the African Union, and in that capacity she addressed both the ICJ in the Chagos and Occupied Palestinian Territories advisory opinions, and the ICC in the al-Bashir case. Before that, she's had a long career as a diplomat, lawyer and academic, including as the former ambassador of Egypt to Rwanda and the former legal advisor of the Egyptian mission to the UN in New York. Tafadzwa Pasipanodya is a partner in the International Litigation and Arbitration Department of Foley Hoag and chair of its Africa practice, as well as being vice president of the African Society of International Law. She's represented sovereign states and state entities from all over the world in international disputes before the International Court of Justice, the International Tribunal of the Law of the Sea, and arbitration tribunals, and she's also a member of the ICC Court of Arbitration. Now, I'm really pleased that we can sit down today and talk about the role that African states are playing in the protection of human rights through international litigation. This is something that you've both just spoken about on an excellent panel session, if I can say so, at the American Society of International Law's annual meeting here in DC, and we had some questions that we wanted to explore further with you. So my first question is for Ambassador Negm, and it takes us back to when the two of us, in fact, first met. This was in the process leading up to the ICJ's Chagos advisory opinion, where you were the legal counsel of the African Union. And that advisory opinion, as listeners may know, dealt with the process of decolonization of Mauritius in the 1960s, including the mass removal of the population of the Chagos archipelago so that the United States could create a military base on the island of Diego Garcia. Now, listeners may not be familiar with the extent to which this advisory opinion came about through the action of the African Union, of which Mauritius is, of course, a member. Can you give us a sense of the diplomatic and political background to how that came about and why the African Union considered this an important initiative?
I would start by saying why it was important or how it started. As you just mentioned, Mauritius is a member of the Organization of African Unity, which is the predecessor of the African Union as we know it today. And Mauritius took its time after independence in order to start calling for the regaining of the sovereignty of the Chagos archipelago. During that time, let's not forget that Africa suffered of colonialism, and the main target of OAU and the objective of the African Union remains ending colonization for our territories. So it came natural that when Mauritius knocked on the door of the organization, had decisions adopted to support its call for regaining sovereignty over the Chagos. Later on, when Mauritius wanted to go the extra mile and go before the ICJ, it had been done through coordination between Mauritius, the African Union, as well as the African Group of States in New York. And they were the catalyst behind proposing the question before the General Assembly to take it to the ICJ. So that is the part and parcel of why we got involved in it. And it remains like a main goal for Africa and the African Union to keep supporting our states when it comes to end colonialism. And the step further was the African Union itself to address the ICJ, which has never happened before. It was the first time in history where the organization stands before the court, and it was a decision taken within the Commission. At the time, I was the legal counsel, initiated the proceedings and initiated the request with the chairperson of the African Union Commission in order to stand as an observer organization before the ICJ. And then the ball started to roll, and we ended up doing, I would say, a very good job before the ICJ.
I would say so. That was the first advisory opinion that the ICJ had been asked to give in some time. And it was the first since Namibia and Western Sahara in the 1970s, which had related specifically to Africa. What do you see as the significance of the fact that the ICJ was being asked to consider decolonization in the modern era on the initiative of African states themselves?
Well, again, it's just like if you think about it of the global situation at a certain point and how the political dynamics work, and Africa is not like different than other states defending its own interests. And going through the path of cases before the court is not an easy path for Africans, not because we lack expertise, it's simply because it costs a lot of money. So going in contentious cases or advisory opinions is not an easy decision. Yet, if Africa and African states find themselves in a position that they really need to go there, we knock on the door of the ICJ. So this is, in a nutshell, one of the reasons why you would see differences in the representation of the African states in advisory proceedings. It depends on how important it is on the interest list of the state. I do believe African states started to realize that they really need also to be more engaged before the ICJ, not only on the UN level, because of course the UN level is less costly for them, but then they realize they need to be heard because the court, with the increase, as you mentioned, of the number of cases, issue lots of opinions that at the end of the day from us as lawyers see it as obligatory because they came from the court. So certain interpretations might affect the interests of African states. So it became part and parcel of the work of African states. And that's why we start to see some increase. But at the end of the day, because of what's happening globally now, the court is not anymore a court of last resort. It will become more and more involved in global affairs, including African affairs, because this is the tool today that Africans can resort to.
Thank you. And turning to Tafi now, I want to take us forward in time to the present day and the Gambia versus Myanmar and South Africa versus Israel cases, both pending before the ICJ under the Genocide Convention. These are both cases in which the applicant state is not the direct victim, but relies on the erga omnes nature of the prohibition on genocide in order to bring really what is essentially an actio popularis. Now, of course, every state is different. They can't all be spoken about in one breath, but do you think there's a particular reason why in both cases it is African states that are standing up for the protection of human rights of people beyond their borders?
Thanks, Chiara. Indeed, every state is different and also every case is different, so it's hard to generalize. But I think solidarity is an important word when one thinks about African states and what's happening at the ICJ. Solidarity because community and the concept of Ubuntu, I am because we are, is a concept and a notion that has resonated with African peoples for a long time. And how that solidarity manifests itself is different with each case. But I think in both of those cases, there's elements of that. With the Gambia-Myanmar case, it's interesting that the Minister of Justice of the Gambia at the time when the case was brought, Minister Tambadou, happened to have worked at the ICTR prior to being a minister. And so he obviously had prosecuted genocide in Rwanda. And push forward various years, he's a Minister of Justice and happens to be part of a delegation a delegation of the Organization of Islamic Conference traveling to the Rohingya camps and sees what's happening, hears what's happening, and it resonates with him because of what he had seen as a prosecutor for Rwanda, and is able to motivate his country and to stand up and with the Rohingya, despite them being so far away from the reality of the Gambia. And that obviously then sets this important precedent that then South Africa, acting also, I understand, in solidarity with Palestine, because of the fact that Palestine historically had also stood with South Africa when they were fighting apartheid. And you see this solidarity, this need to stand with other people and realizing that we are this community after all, that appears to be motivating them.
Thank you very much. It's very interesting. So now maybe taking a step forward, talking about solidarity, and we talk about these two specific cases. So in a sense, we have a limited amount of data, but do you think that this might be part of a trend of African states becoming possibly assertive in the protection of universal rights? So not only genocide, but universal rights. And if so, what do you think might be some of the factors that contributes to this?
Yeah, it's hard to speak of a trend, but I think that perhaps is a trend, and time will tell. But I think that to see the Gambia, the small country, act in this way did motivate a lot of people, and I think we'll see more of that. We're seeing also this trend not across the world. I think that Latin America has been at the forefront in different other cases related to climate change, and we will see it because the states are more engaged in seeing the power of international law, I think, but also the lawyers behind the scenes are participating more, and I think as lawyers and advocates, we have this role we can play of showing our clients what's possible and encouraging to take that route.
I have a question for both of our guests today. What do you think are the implications of these types of cases for the future, where you have third states who are choosing to use international courts, such as the ICJ and others, to sue in order to protect the rights of other states or to protect more universal rights, such as the right to a healthy environment? In other words, what do you think we will see in the future? Will this trend continue? Will we see other states continuing to use courts in this way? What do you think are the implications?
Thank you very much. So I think it's a very interesting question because picking on what Tafi said about the trend, it's yet to be seen whether we will have an increase or not. But given the current global situation on different issues, you just mentioned climate change and the right to a healthy environment. But if you think about migration issues, refugees, the issues in relation to the conflicts, the respect of the Yusimbelo, the threats to grab land by force, the threats to sovereignty of states, which might kill the Westphalia Principles, which basically the original of the current international law regime. With these threats, I would say we'll find more states, specifically African states, interested in going through this path, not necessarily to defend the others per se, but they have, again, interests at stake. And if we think about if we speak about universal human rights, I would say African human rights, because we are like the right to a healthy environment. We are the only ones who put it as a mandatory obligation, not part of soft law. So going through the SDGs, the development issues, all of these, with a lot of threats going around, you will find in the corridors many discussions, okay, how can we act on it? And if it threatens the maintenance of peace and security globally, and the Security Council fails to act, then they leave no space for states other than going to adjudication, be it through advisory proceedings or contentious cases, depending on jurisdiction. But this is basically, I would see it might increase because of the global political international dynamics.
Agree. I would just add to that on healthy environment, I think it'll be very interesting to see what happens after the court issues its opinion on state obligations concerning climate change. But I think that will open, depending on what those obligations are, we'll see states trying to use the courts more to gain or to defend themselves. So let's see.
One thing I'm wondering is, I'm thinking about the fact that many African states and the African Union are now taking part in advisory proceedings. So, for example, before ITLOS, before the ICJ, on climate change, on Palestine. Do you think this stems from, among other factors, a growing level of comfort or confidence that African states have in international courts and tribunals? Do they feel these days that the composition of those tribunals is something that makes those tribunals more able to hear the perspectives that those states want to bring?
I would say it's more than that. It's the resort to a sane group of people that might speak on the law in a balanced way. Because if you, again, take it out of the political dimension, at the end of the day, the UN is a political organization. Let's not forget that. And the ICJ is the main judicial arm of that organization. And international law is always a balance between politics and rules. So the interpretation, when it goes so astray in the political sphere and the discussions, developing states and African states find the main resolve of this issue will be the ICJ. And that is important to bring to the table. At the same time, as Safi just mentioned, when we speak about different rights and obligations in the climate change, for example, we have our regional mechanisms in Africa and for the African Union. And there are attempts from different parties to try to undermine these regional mechanisms. And part and parcel of either strengthening it or empowering it at the same time, maybe to a bit make sure that what we bring in, like the African Court for Human and People's Rights, resonates also with what the ICJ says in certain aspects. So with this, it makes it acceptable and agreeable to the states to go. And with the increase of the advisory opinions, we show the increase of the African Union involvement as an organization. It's just like, it's as if I opened the Pandora box when I was at legal counsel. And then also, no one perceived at the time of Chagos that we will have this spree of advisory opinions. I don't think the court itself had ever witnessed on its dock this number of advisory opinions at a time. But it's simply because this is the only way now to move, and we are still moving within the peaceful settlement of disputes, which is very important to think of, coming from like a region that is still in turmoil, and we have almost 23 conflicts on the continent right now. So it's important to try to keep resorting to peaceful means to settle the disputes rather than end up in conflict. So that's why I see the trend increasing.
One question on a slightly different note, although it's related, is to both of you. You're both accomplished and powerful court advocates, and I can say that from first-hand experience of hearing you both speak in the ICJ. But it's no secret that there's still a dreadful lack of diversity in the advocates who stand at the podium in the ICJ and in other international courts and tribunals. There's no one simple answer to this, but what needs to change, what needs to happen to rectify this situation, which I'm going to use the word shocking for, I still think?
Yeah, it's a really important issue, and I think that one way that it has started to change and will continue to change is with the states or actors, the clients in international law actually caring about this issue. Because if clients in states, in particular, if we're talking about public international law, demand this to see, and they understand the wealth and creativity that comes of having a diverse team representing them, and they demand that of the firms that are representing them, then the firms will change because they would like to serve their client. I think that counsel can also do more. I was on a case. It was an ICJ case where one very well-known white male counsel said that he wasn't going to continue unless there were more women who were on the team, which was which was very powerful. And it shows it's not only just to clients, we can all speak up and talk about this importance and how it would benefit the teams if they're more diverse. So we all have a role. I think the advisory opinion proceeding on climate change was wonderful for many reasons. One was just to see the diversity of advocates there, because there were so many states participating in organizations, and they had a variety of advocates. And I think that showed to the world that you don't have to have fled before to be amazing at the court. You don't have to look a certain way. You don't have to dress a certain way, and you can be a powerful advocate. So hopefully that's helping and will lead to even more diversity.
I would just add to this that those who are in the minority group, specifically women and people of color, they should disregard the type of discrimination and condescending language that they get from the dominant club before these courts. I was just advising someone after the panel, so forget your gender, forget what you're doing. You just focus on yourself, focus on delivering. I don't want to be recognized because I'm a woman or because I'm an African or because of whatever heritage that is part of me. I want to be recognized for my work, for my credibility, for the ability to deliver. And this will not come out of nowhere. All of us here around this table work very hard to reach certain levels in our work and to make sure that we advance. And if we keep focusing on the negative things that we faced in our lives, and I'm sure all of us face certain things in our work environment, but if you focus on this negative aspects, you're not going to progress. But I want to progress, then I will forget that I'm a female, I'll forget that I'm dark, I'm going to forget that I'm from where I'm coming from. I'll just focus on my work, and I will prove my worth through my work. This is the most important thing I do believe we all have to focus on, because this is how we can advance. Otherwise, the outcome, we don't achieve enough, and we'll come back in 10 years complaining that we don't have the diversity. And I believe this is something crucial to focus on.
Thank you. And actually, to follow up immediately on this, to a question for both of you, what would you say by way of advice to talented young African lawyers starting out and wanting to build careers in international law? What is your specific advice?
I couldn't agree more with Ambassador Namira that, it's all about your work, and your work is your worth. And so I just encourage people, since your question is particularly about young African lawyers, to really do their best with their work and to take each opportunity and throw it out of the park, because it matters. It matters. And we do sometimes have to work harder to show our worth, but it's worth it. And if you love what you do, you should be happy to give your best for your work. But you need to do that with each assignment and each opportunity. But at the same time, a second thing I would say is that you will make mistakes, and you shouldn't be defined by those mistakes. So sometimes there's a tendency to feel that because we are in a underrepresented group, we have to be perfect, and to hold ourselves up to a standard that is unmaintainable. If we're going to do work, we're going to make mistakes at some point, and to realize that you can learn from those and not to be crippled by it, and kind of keep moving the way that anybody else who's not underrepresented can make mistakes, learn from them.
Well, I'd complement that by saying be patient, because if we go specifically for public international law rather than arbitration and private international law, most of those from African descent or Africans in Africa would say, okay, that's not the work that makes money, because it's it takes states and it's a club of a few and it's dominated. How can we go from there? So I would say start, but be patient and continue. And as Steffi said, you work on yourself, and you work on yourself, you will end up somewhere. We really need specialists of public international law on the continent. If we want to make sure that our interests are defended by us, by bringing our values out there, then we need the representation from within. And this representation from within will not come in a vacuum unless we work hard for it. And this is something I think it's important for all the Africans to know, that there is a huge space for international law today more than ever, and for the job of a counsel or an academic in international law or a researcher. We have a lot now, and we have so many fields in international law that our states need advice on. Instead of knocking on the doors of someone outside, I'd rather go to my national or to go to my neighbor rather than cross the continent to find a remedy or a solution for my problems. And this is something will not happen unless the new generation who is now studying law try to specialize in public international law fields and find their way through work. And as Tafi said, yes, we will make mistakes. We all made mistakes, but it's important to rectify it and move on. Trying to be perfect in a work environment is mission impossible. We all tried that. But the whole thing is, yes, we will do double the effort than maybe another male colleague or someone else next to us. Yes, we'll do double the work, but it pays back at the end because we're patient and persistent. So that's my advice.
I have a similar question along the same lines. As some of our listeners might know, there is a Women in International Law interest group here at the American Society of International Law, a group whose purpose is to advance and support the career progression of women in international law. Asking this question as past chair of this group, do you have any particular advice, in addition to what you have already shared with us, for talented young women starting out and wanting to build careers in international law, and particularly before these institutions, which, as we've already discussed, have traditionally been dominated by white men?
Thanks, Milena, and thanks for your leadership within WILIG. WILIG is so important, and I would encourage young women to join WILIG, to join interest groups at ASOL. WILIG in particular has an amazing mentoring program that's really useful. But also look for mentors who are not women, and they will also help you advance. And on a less practical level, and a more mindset level, I would say to young women that they should step into their power, because often we are limited by what we think people are thinking, and yet we are so powerful, and we know we can do almost anything we want to do, at least not limited by anything more than our male counterparts. So just to realize the power that you have, it's not any different than anybody else's. So step into it.
My advice is raise awareness among young students who are studying law and willing to choose international law as a career path. Showing case of success stories of like women who might have come from privileged backgrounds and they reached new heights, or those who didn't have the chance to come to the Western Hemisphere and still they progressed. There are many, many amazing stories that can empower the young women to join the interest group, to understand, to have more programs with the different organizations out there between like think tanks, academia, and reaching out to them and speaking to other similar entities that are working for women, encouraging them to join international law, I think will add value to the work. We have the African Women Lawyers Institute is doing a marvelous job in Africa, for example, and to try to showcase to the African girls and women that they can do like all the others, the judges, the international lawyers, the counsel, and so on. So that's going to be of real added value, because you can join in programs together to disseminate the information. And also, I think a crucial issue in this is addressing the discrimination, the harassment, raising the awareness of the girls and women of the rights under the law. And believe me, it's under every national law. Like I've been in the continent now, I'm African, but working for the African Union for 8 years now. And I can see in the different legal systems, the national legal system, there isn't one that will not address harassment at work. So this is something, and I'm not only speaking about sexual harassment, administrative harassment, all types of harassment. So it's important to make them know that they can speak out. They shouldn't shy away. They should keep fighting. The work environment for women in law is a war zone. It's a fight. You have to keep going and going and going. And raising their awareness of their own rights will encourage them to go. They know they are protected. This is important.
Thank you so much. We wish we had more time, but it's time to wrap things up. So huge thanks to Namira and Tafi for being our guests today and being so generous in sharing your insights on these very important issues. I've really enjoyed our conversation. I'm sure my colleagues also did. And if our listeners have too, you can join us on the first Monday of every month for more international law chats.